Hi everyone, Derek Johnson with Tatango.com. I'm here at Innovista Law, the home of the TCPA Defense Force, talking to Joe Bowser, who's a TCPA attorney. And essentially the question I wanted to ask you, Joe, was what happens when a business violates the Telephone Consumer Protection Act? And maybe first let's start off with what is the Telephone Consumer Protection Act and how can you violate it with text message marketing?
Sure. So the Telephone Consumer Protection Act, I'll call it the TCPA, is a law that is designed to protect consumers from unwanted text messages, telephone calls, and faxes.
Okay.
It's where the DNC, the Do Not Call list rules, are housed, and it applies to text messages as well, even though the law never mentions text messages.
That's a good point.
So the law itself has a number of penalties. Private citizens who have been damaged by unwanted calls or texts can sue in federal court, or state court for that matter, for the damages. The law provides statutory damages of $500 per call or text or fax, up to $1,500 if they can prove that the defendant willfully violated the law.
And the defendant, in the case of like text message marketing, would be the brand sending the text messages.
At a minimum, the brand, but perhaps also the platform provider, perhaps also the marketing agency that designed the campaign.
So everybody involved, essentially,
is at risk.
Okay.
Is at risk. The courts will look to, who was really responsible for the campaign, and there are certainly campaigns where more than one party is responsible, but for the most part, and each one of those won't be responsible for the 500 for the same call.
It's the whole. Somehow it has to equal $500 to $1,500.
Right. They may share that responsibility, but the plaintiff can get it from just one, which is often the brand that actually has the resources to.
Okay. So, and you say damages. How can you claim that someone was damaged, like physically, I guess, damaged by receiving one text message?
Damages is just a term of art in the law for the amount of money you can recover for a certain harm.
Oh, so you don't need to claim that I was emotionally hurt by this text message or I was physically hurt by this text message.
No.
Or it interrupt my dinner.
No.
Okay.
No blood, no bruises.
And it's $500 to $1,500 per text message.
Exactly.
So that's a pretty big.
Congress wanted this to be a deterrent.
Okay, it is, I'm guessing, right?
Yeah, no, it certainly adds up quickly, particularly in the SMS context. So you don't have to have any harm, and there was a legal controversy around a case called Spokio about the extent to which some people don't answer the phone. They didn't actually read the message.
They didn't even see the message.
You deleted unwanted text just like you deleted unwanted email.
Okay.
Just swipe and delete, right? No one cared.
Yep.
And then there are plaintiffs who have many cases against numerous defendants. They want these cases because it is their business.
Yeah.
Right? They're in the business of suing people for TCPA violations.
Interesting.
I have a case where this plaintiff has a case pending against 10 other companies.
So it's the same person that is claiming that they were damaged by all these different brands for the text messages they received.
He is not employed except to pursue TCPA claims.
What is the technical term for that? It's a
professional plaintiff.
Professional plaintiff, okay.
Right.
And what's the difference between the $500 and the $1,500?
So
why would there be a different cost?
So the TCPA is what's called the strict liability statute. They don't care if you knew you were violating it, if you tried your best but still violated it. If you violated it, you are liable. The base level of damages is $500 per text.
Okay.
But if they can prove that you willfully violated it, that you just didn't care, you knew that you shouldn't be texting people without their consent, and you did it anyways.
Yep.
Or you were so reckless, right? And recklessness requires a kind of heightened level of ignorance, right? You really need to play ostrich there, but if you willfully violated the act and just sent the messages without regard to the liability, you can be liable for $1,500. Fortunately, that doesn't happen a lot.
Because I feel like most brands, they want to follow the TCPA.
Right.
Like, if you're going to be sued for $500 to $1,500 per text message just for getting opt-ins and getting the right type of opt-ins, like why not just get the opt-in?
Right. No, the brands that really try to comply, if there is exposure, a lot of times it's around gray areas in the law. Right? Different courts have different interpretations about what a different provision might mean. There's a big problem with reassigned numbers. So you get consent from consumer A. They lose their phone number. It gets recycled to consumer B. Well, they didn't give you consent.
Interesting.
Right? So they sue you saying, I don't know you. Why are you texting me?
Yep.
You were never told by consumer A, hey, I lost my number.
Yep.
Right? They don't have their phone to call you.
Yeah, exactly.
So
it sounds like just a big issue is that, there are a lot of things that can go wrong with TCPA compliance. Getting a good software provider, a good attorney, making sure that the employees that are sending the text messages, managing the campaign are aware of TCPA compliance.
Training is huge.
Okay.
Training is huge because you want people to be sensitive to these issues.
Yeah.
Because if it's only the general counsel's office that knows about this, and the folks on the marketing team just aren't sensitive to these issues, they don't know to get it back to legal until it's often too late.
I think we see that a lot is, general counsel will come up with a lot of rules and regulations. They might not even communicate that to the person that is sending the text messages or managing the campaign. Mm-hmm. And it seems like this needs to be an all-around team effort.
Or they'll draft the memo in 2013.
Yeah.
Well, the rules have dramatically changed since 2013. It needs
so this
to be
ever
refreshed.
Evolving.
Right. I mean, new cases come out every day.
Okay.
Circuit level cases come out weekly. These are things that you just need to pay attention to because the standards shift materially and can differ materially between circuits.
So locations.
Okay. Exactly. So what's okay in New York may not be okay in California.
Jeez.
So you just want to make sure that if you have a national campaign, you're complying with that heightened standard.
Okay. And really, I think it comes down to is, first off, comply with the TCPA.
Right.
When you're doing text message marketing, it applies to text message marketing, right?
Absolutely.
Yep. There's no ifs, ands, or buts there.
Take that to the bank.
If for some reason you violate the TCPA, whether it's you're doing it on purpose or you made a mistake, the fines, it's not even a fine, it's, what is it called?
Statutory damages.
Yeah, so it can be anywhere from $500 to $1,500 per text message.
Right.
Okay.
And that's just the lawsuits.
There's other stuff.
FCC and FTC and state attorneys general can pursue claims as well. And they have their own level of statutory fines and penalties.
So this is just something you always want to follow the TCPA. There's really no reason not to follow the TCPA.
It's meant to keep consumers happy, which is something the brand should want.
Interesting.
There are hoops, of course, but
yeah, well, it's good to know because
ounce of prevention.
With such large $500 and $1,500, it is definitely worth it to go get legal counsel. Make sure your whole team is on board. Make sure they're constantly being updated on what is happening with the TCPA. It sounds like a team effort, essentially.
Yeah, that heightened level of statutory damages is why the TCPA litigation is the second most common type of litigation in federal court.
That's crazy. So you're saying, like, out of all the stuff that goes to federal court, most of it is like TCPA.
Securities cases, employment cases. TCPA is the second most common kind of litigation filed in federal court.
And huge damages too. It's $500 to $1,500 per text message.
Because the plaintiff's attorneys see the statutory damages available, pursue class action relief, get the settlement, get the yacht.
Sounds like a good deal for them. Okay, my name is Derek Johnson with Tatango.com, and I'm here at Innovista Law with Joe Bowser, and he is part of the TCPA Defense Force. Thanks for watching our video today. If you like this video, be sure to give us a thumbs up on YouTube. If you want to see more of these types of videos, be sure you subscribe to our YouTube channel. And if you have comments or questions, please leave a comment or question in the comment section below.